Hello everyone. Today we are starting the Indian Evidence Act 1872, which explains how court decides facts in a case. Words like evidence, facts, and proof look simple, but in the law they have special meanings. That is why in this first video we are studying section 3, which explains these basic words. Let us look at the introduction of the Indian Evidence Act 1872. It is a law that explains how courts decide facts in a case. It tells the judges what material they are allowed to look while giving a judgment. Courts do not decide cases based on emotions, sympathy, or personal opinion. Every decision must be based on only on legally accepted evidence. This act gives rules to separate truth from falsehood. Without these rules, courts would not be able to give fair judgments. Therefore, the Evidence Act plays a very important role in the justice system. This act does not create rights or duties for people. Rights and duties come from other laws like IPC, CPC, CRPC, BNS, or Contract Act. The Evidence Act only explains how facts relating to those rights and duties should be proved before the court. That is why it is called a procedural law. It controls the method of proof, not the substance of law. Whenever a case comes before a court, the judge applies the Evidence Act to test the truth of facts. Every trial depends on this process. Section 3 is the most important part of the Evidence Act because it defines the basic words used in the entire act. Words like evidence, fact, fact in issue, and proof are explained here. These words are used again and again in all the sections and in court judgments. If these meanings are not understood clearly, the whole subject becomes confusing. That is why section 3 is always studied first. It creates the foundation for understanding the entire Evidence Act. Now let us look at importance of section 3. This section 3 is important because it gives legal meanings to common words. As we discussed, words like evidence and facts are used in daily life, but in the law they have special meanings. Courts do not use these words in general sense. They use them in a sense given under section 3. That is why this section controls the language of Evidence Act. Every judge, lawyer, and any legal aspirant must follow these meanings strictly. No other meaning can be applied here. Judges use this section 3 while writing judgments. Lawyers use it while arguing case before the court. Aspirants, legal aspirants or students use it while answering questions in the examinations. Before a court records any evidence, it first identifies the facts in issue. This identification is done using section 3. Only after that does not court only after that does the court decide which facts are relevant and which evidence can be recorded. Understanding this section properly makes the rest of the act logical and easy. Now let us look at meaning of evidence. Evidence means the material which is placed before the court to prove or disprove a fact. A court cannot decide any case without the evidence. Judges are not allowed to use personal knowledge or information from outside the court. Whatever the judge relies upon must come before the court in a legal manner. Evidence helps the court to know what really happened. It connects facts with with the final judgment. Therefore, evidence is the foundation of every judicial decision. Now, according to section 3 of the Indian Evidence Act, evidence includes only two things. The first one is it includes statements made by witnesses before the court. These statements are called oral evidence. Second thing, It includes documents produced before the court for the inspection. These documents are called documentary evidence. No other material is treated as evidence unless the law allows it. Evidence must always be produced during the trial. Anything outside this process has no evidentiary value. Courts often decide cases only on the basis of evidence. Even if something appears to be true, the court cannot accept it unless it is proved by evidence. This rule protects fairness and justice. Both oral and documentary evidence must follow legal rules. Improper or illegal evidence is rejected by the courts. Therefore, understanding the meaning of evidence is very important. Without evidence, no judgment can stand in the law. Now, let us look at oral and documentary evidence. Oral evidence means statements made by witnesses before the court. These statements must relate to the facts under inquiry in the case. A witness must come before the judge and speak during the trial. Statements made outside the court do not become oral evidence by themselves. Oral evidence must be direct and relevant to the case. The court listens the witnesses carefully. Oral evidence plays an important role in many criminal cases. When a witness gives oral evidence, the court checks its truthfulness through cross examination. The witness is asked questions by both the sides. This helps the court find whether the witness is reliable. Oral evidence depends greatly on the credibility of the witness. If the witness is trustworthy, evidence becomes strong. If the witness is doubtful, oral evidence loses its value. Therefore, courts test oral evidence very carefully. On the other side, documentary evidence means documents produced before the court for inspection. Documents include written papers, printed materials, and electronic records. Emails, WhatsApp messages, audio recordings, and CCTV footages are also considered as documents. Documentary evidence provides written and recorded proof. Courts often prefer documentary evidences because it is a permanent. However, documents must also be proved according to the law. Unproved documents have no value. Now let us look at what is not an evidence. Not everything connected with a case becomes an evidence. Only material accepted by the court according to law is treated as an evidence. Many students or many aspirants we wrongly assume that all investigation material is an evidence. This assumption is not correct. The Evidence Act clearly separates evidence from investigation material. Courts are very strict about this distinction. Evidence must pass through legal rules. Without following these rules, material cannot be relied upon. An affair is not evidence by itself. A statement given to the police is not an evidence. A confession made to the police is not an evidence. These materials are part of investigation and not the proof. They may help the court understand the case. However, they cannot themselves decide guilt or innocence. Courts use them only for limited purposes. Treating them as an evidence is a legal mistake. An affidavit is also not an evidence unless it is proved according to the law. Affidavits are written statements, but they must be tested in the court. Evidence must be placed before the judge and accepted legally. This rule protects accused persons from unfair convictions. It also ensures fairness in civil cases. Therefore, understanding what is not an evidence is also an important and understanding what is an evidence as. Now let us look at meaning of fact. A fact means anything which can be perceived by the senses. This includes things that can be seen, heard, touched, or felt. Facts form the base of every legal case. Without the facts, there can be no dispute before a court. Facts decide rights and liabilities of the parties. Courts often examine facts through evidence. Therefore, facts play a central role in every trial. Facts are not limited to physical objects. Facts also include mental conditions of the person. The Evidence Act recognizes both physical facts and mental facts. Physical facts are easier to understand because they are visible, as and mental facts are related to what was going in the mind of a person. Both these type of facts are equally important. Courts, however, examine both carefully. If facts are not proved, rights cannot be enforced and liabilities cannot be fixed. That is why court insists on proof of facts. Facts must be connected with the case. Irrelevant facts are ignored. Only those facts which matter for the decisions are examined. Therefore, the meaning of fact is essential for applying the Evidence Act properly. Now let us look at what are physical facts and what are mental facts. Physical facts are facts which can be directly seen or touched. This includes injuries, weapons, bloodstains, dead bodies, or damaged property. Physical facts usually form strong evidences. They can be proved through witnesses or documents. Courts find physical facts easier to verify. Such facts are often supported by photographs or reports. Physical facts give clear information to the court. On the other side, mental facts relate to the state of mind of a person. These include intention, knowledge, negligence, or good faith. The mental facts cannot be seen directly, they exist only in the mind of a person. Because of this, they are more difficult to prove. Courts must rely on surrounding circumstances. Behavior and conduct help in proving mental facts. Court often infer mental facts from action of a person. What a person did before, during, and after an incident becomes important. For example, bringing a weapon or running away from the scene may show intention. Mental facts are very important in criminal cases. Without proving mental facts, guilt cannot be established. Therefore, courts examine conduct carefully. In the previous slides, we had understood what is meaning of fact. Now let us look at what is meaning of fact in the issue. Fact in issue means the main disputed fact which the court must decide to give judgment. These facts decides the final result of the case. They are the most important facts in a trial. The entire case revolves around these facts. Evidence is recorded mainly to decide facts in the issue. Courts focus on these facts first. Without deciding them, no judgment is possible. In criminal cases, facts in issue are decided by the charge framed against the accused. The charge tells the court what exactly is alleged. In civil cases, facts in issue are decided by the pleadings of the parties. Pleading shows what is admitted and what is denied. Based on this, the court identifies facts in issue. This step is essential for fair trial. Once facts in issue are identified, the court decides which evidence is relevant, and irrelevant evidence is not allowed here. This saves time and avoids confusion to the courts. Facts in issue guide the entire trial. They help the court reach a clear conclusion. Therefore, understanding facts in issue is necessary to understand the structure of the trial. Now let us look at what is fact versus what is fact in issue. There may be many facts connected with a case. However, not all facts are facts in issue. Facts in issue are only those facts which are directly affect the final decision. Other facts are supporting facts. Courts do not treat all facts equally. They give special importance to facts in the issue. This distinction helps the court focus on what really matters. Other factors Other facts are considered only when they help to prove or disprove the facts in issue. If the fact does not help in this way, the court ignores it. This prevents unnecessary evidence from being recorded. It also saves time of the court. The trial becomes more efficient. This distinction is very important in a legal aspects. Understanding the difference between fact and fact in issue helps students to write better answers. It is also helps lawyers present cases properly. Courts decide cases based on fact in issue, not on every small detail. Therefore, this distinction is central to the Evidence Act. Without this clarity, trials would become confusing. Now let us look at proof under section 3. A fact is said to be proved when the court believes that it exists. The court may also treat a fact as proved if it is so probable that a reasonable person would act upon it. Proof depends on the belief of the court. This belief must be based on the evidence. Court do not act on guesswork. Proof gives certainty to judicial decisions. A fact is said to be disproved when the court believes that it does not exist. When the court is unsure, the fact is said to be not proved. This situation is common in criminal cases. The concept of not proved protects innocent persons. It ensures that no one is punished without strong proof. This rule supports fairness in the justice. In criminal law, guilt must be proved beyond reasonable doubt. If there is a doubt, the accuser gets the benefit of doubt. In civil cases, proof is based on balance of probabilities. Proof completes the trial process. Every judgment is finally based on the proof. Therefore, proof is the final step in the Evidence Act. In this video, we studied Section 3 of the Indian Evidence Act and understood how courts use evidences to decide facts in a case. We learned the meaning of evidence, facts in issue, and proof. Also, understood why only legal accepted material can be relied upon the court. In the next video, we will study relevancy of facts and learn which facts the court will accept and which facts the court will reject. If you found this video helpful, please like, share and subscribe. Thank you for watching.